Second, let's talk about the GAO report that was issued on August 4th. I had received a draft of the report in June and was very disappointed in its analysis and conclusions. I was unable to discuss it in public because GAO has asked us not to do so until the report was released in its final version. As you know, I have been considering the option of challenging aspects of the so-called federalization law in court. I have said many times that we do not object to the application of the federal immigration laws aimed at protecting our borders and our national security. We welcome that. But we do object to the provisions of the law that seek to eliminate over time all foreign workers in our community who cannot meet the very restricted requirements of H visas under federal law. We have about 18,000 foreign workers in the Commonwealth, about 2/3 of our total workforce. Only a percentage of these workers is likely to qualify for H visas. The others will be allowed to remain in the CNMI only if federal officials give special CNMI-only permits to individual employers, allowing them to hire foreign workers. But the law requires that the number of these special permits be reduced to 0 by year 2014, unless the U.S. Secretary of Labor grants an extension of the so-called transition period. When this law was being considered in Congress, I and others from the CNMI testified that our economy depended on these foreign workers and that the reductions being considered would severely damage our economy. Congress clearly did not listen. The bill as passed was more damaging to our community than the bills on which I testified. Although GAO denies doing so, its reports confirms our worst expectations regarding the damage we can expect if this law is implemented as written. First, the report refers to a well-respected book in economics authored by the present chairman of the Federal Reserve Board, Ben Bernanke. According to Ben Bernanke's book, a 10% reduction in the number of workers in the U.S. might be expected to cause a 7% decline in the economy. So for the Commonwealth, a 60% reduction in our workforce over whatever time period would result in a 42% decline in our economy. Second, the GAO's estimates are very similar. Of a total of 9 scenarios outlined in the GAO report, the agency discusses only 2, which assume that the U.S. Secretary of Labor will regularly grant extensions every 2 years. Even with these very favorable and unrealistic assumptions, the GAO reports that the CNMI economy will decline by 30% in one case and 50% in another case by the year 2021 as a result of the new law. Think about this for a minute. Think about driving down Beach Road with 50% of the businesses gone. Think about Mill Road. Same thing. 50% of the businesses are gone. This is a terrible and drastic result. During the Great Depression in the U.S. during the 1930s, the country lost only 18% of its economy. We asked for this GAO report before Congress acted. It might have done some good then, before the members of Congress acted on the bill. We did not ask for their assessment after Congress acted, because that would do no good at all. In fact, the passage of this legislation is seriously affecting our investors, present and potential. I am meeting day and night with investors, both local and foreign, to assure them that we can deal with this challenge. At the same time, some in the media are complaining that I am not available to meet with them and answer their questions. For a governor, the choice is clear. It is more important for me to spend time with our investors. This is a hard problem. These investors do not understand why the federal government would destroy the workforce that serves our economy well. Why would they make the situation so uncertain and so unwelcoming for foreign investors and foreign workers? Why would they deny visa waivers to tourists from Korea, Russia, and China who want to buy condo and timeshares in the Commonwealth? Frankly, I have difficulty in answering these questions. I will be meeting with the legislature next week to review our options for dealing with this situation. I now have the advice from the Washington law firm that I hired several weeks ago to look at the litigation alternative. Litigation may be the only alternative for challenging the labor provisions of the new federal law. This law presents the most serious threat to our right to local self-government that the Commonwealth has ever faced. I remind you that to get this right of local self-government, we gave up 2/3 of Tinian. We gave up Farallon and Indonesia, where the military does its bombing, and most importantly, we gave up our sovereignty as an independent people. I believe that the agreements contained in the covenant were a good deal for us as a people. But the right of local self-government was a critically important part of that deal. If we do not defend our right of local self-government now, under these circumstances, we have little hope that Congress will respect this important right in the future. When I have finished consulting with the legislature, with the business community leaders, and others in the community on this particular issue, I will report back to the people. Thank you, si Diyos masi and olumay. Tafan manatuzot, ja si Diyos utafan pinindisi.